May it please the court, Steele Williams for the appellants, and one of the appellants is here, Phil Wingate, for the record, and I would ask the chair for 2 minutes for rebuttal.
Sure.
As a brief procedural background of this case, a jury verdict of $190,000 was entered or was rendered December 2009 against Burro Incorporated and individual defendants, the Davies. The final judgment on that verdict was entered July of 2010. A motion for proceeding supplemental was filed September of 12, seeking to implead Burro Building and Maintenance Incorporated. The basis of that proceeding supplemental motion was at issue in an evidentiary hearing in 2014. In 2012, when the proceeding supplemental motion was filed, the court granted the motion and impled Burro Building and Maintenance Incorporated as a third-party defendant to the case, and directed that this motion for proceeding supplemental be served and a summons be issued to that defendant. Thereafter, the motion for proceeding supplemental and a summons was served on the impled defendant, Burro Building and Maintenance Incorporated. The motion for proceeding supplemental that the new impled defendant received asserted that Burro Incorporated, which was the subject of the jury verdict of $190,000 in the case, had simply transferred its business to Burro Property and Maintenance Incorporated. I apologize, I've been saying Burro Building and Maintenance. And it also, the motion that the new impled defendant received had attached interrogatories from Burro Incorporated showing what disclosures, if any, that they had had regarding transfers. It also attached a corporate record of Burro Maintenance showing that Burro Maintenance had the same officers as Burro Incorporated. And it also attached a letter that Burro Maintenance had authored, well, let me backtrack, that defendant, Catherine Davies, who was also subject to the verdict in December of 2009, had authored to Manatee County regarding the business of Burro Incorporated being transferred to Burro Property and Maintenance Incorporated, and that the business was going to be the same, tax ID number was going to be the same, and pursuant to the corporate records attached to the motion for proceeding supplemental, the officers were the same. Now, the new impled corporation defendant, Burro Building, Property and Maintenance, was served with a summons which directed it to, oops, excuse me. This is new for me. The said impled defendant is required to serve written defenses to the motion for proceeding supplemental and impleader of third parties. In response to that summons and the very detailed motion that it was served with all the attachments, Burro Building and Property Maintenance sent a letter into the court asserting, in substance, I would like to just state that whatever Catherine Davies and Ralph Davies did was outside of the transaction we did with them and has nothing to do with us. Now, the motion for proceeding supplemental asserts that a transaction occurred in April of 2010 where Burro Incorporated transfers its business to Burro Building and Property Maintenance, and in response to those allegations, Burro Building and Property Maintenance asserts it's under new individual ownership now.
Yeah, the company was ultimately bought by an entity called Greenscape Incorporated. Is that?
Greenscape is the parent corporation of Burro Building and Property
Maintenance.
Maintenance.
Doing business as Burro Building and Property, which is the new entity that was formed in April of 2010?
Correct. Yes. And
'Cause
those,
I read the transcript of the proceedings before Judge Dunnigan on, in April of 2014, and it was a little bit confusing because there wasn't a whole lot of discussion about the fact, about the initial change of parties and change of name. It started out as Burro Inc., and then it became Burro Building and Manufacturing in April of 2010, but other than the fact that that happened, there wasn't much discussed about it.
the evidence that was presented at that hearing was centered on that transaction, in that the evidence presented was the corporate records for Burro Incorporated and Burro Building and Property Maintenance, to show that, one, they had the same tax ID number, two, they had the same business location, three, they had the same officers. In addition,
let me clarify, because as I read the briefs, I'm a little confused about what the nature of those transactions were, because the brief says, oh, I take that back. There's a notation here, and it's not directly from the brief. The suggestion that Burro Inc. changed its name to Burro Building and Property Maintenance. Was that true, or was there a transfer of assets to a new corporation?
the only evidence we have of what the Davies did is what Catherine Davies said in a letter to the county, Manatee County. She essentially says, we're transferring the business of Burro Incorporated
new entity.
To the new entity.
Okay.
But at the time she does that, the only difference in the entities is the name. The same tax ID number is being used for the entities. The same corporation, the same officers are being used, the same business location. And it was that transaction that was the subject of the motion for proceeding supplemental.
Was there a new corporation?
Yes, there was a new corporation.
New corporation established.
There was a new filing with the Secretary of State, Division of Corporations. Yes, sir. And those records were made part of the proceeding supplemental evidentiary hearing. But the key
goes on to, it looked like you were trying to establish that Greenscape Inc. was on notice of this and therefore should be responsible for this judgment.
There's two transactions. The one in April of 2010 and then in September of 2010. In April of 2010, which was what the motion for proceeding supplemental was designed towards, was to essentially say the name just changed, everything was essentially the same, so the judgment should attach to the new corporation.
And then the
in September
transaction was a purchase of the corporation, or again, purchase of assets?
It was a purchase of the corporation pursuant to the contract that was...
They paid $200,000
to the shareholders.
To the shareholders to acquire basically 3 contracts. Is that right?
To acquire the corporation that held the contract.
Right.
So I don't see why you would, if they bought the corporation, I don't know how they, if they buy the corporation, I don't know how they escape corporate liabilities that that the corporation owes. So the question would be, because given that then they started operating under that name as well, when I read the judge's order, I'm not sure which entity the judge is referring to when they say Burro Building, it was not shown that they bought with knowledge, or that the transfer was with knowledge.
Well, as to the knowledge aspect, I think there was 2 key points in the evidentiary hearing. The individual purchasers that also owned Greenscape bought Burro Building and Maintenance.
Bought the corporation.
Bought the corporation.
Didn't buy the assets, bought the corporation.
But at the time they bought it, there was no judgment against it. The judgment was against Burro.
The judgment was against Burro.
Burro Inc., not the new entity.
But they were sufficiently aware of, they were buying Burro Building and Maintenance, which was it's in the contract, their sales contract, that Burro Building and Maintenance, also known as Burro Incorporated, explicitly in their contract. Further, the individuals who are in control of Greenscape, who is buying Burro, actually say in their testimony, yeah, we were aware of this lawsuit, but we didn't think these issues had anything to do with us.
Well, the reason they felt that way, if I understand correctly, in July of 2010, the judgment was entered against Burro Inc.
Correct.
And that's where it stays to this day, right?
Correct.
Okay, that was July of 2010.
Right, and then
And
Greenscape
then
buys it in September, but they bought the new corporation. Bought the assets of Burro Building and Maintenance Inc., not Burro Inc.
When was the
The
proceeding
Greenscape
supplementary?
bought the entity, Burro Building and Property
That's when it was
Maintenance,
filed?
all the shares and assets.
That's
And-
when the hearing was held.
and the
No,
issue-
when was the proceeding supplementary
When was the
filed?
proceeding supplementary filed?
It was filed in September of 2012.
Okay,
Long after all this happened.
so July 10 is the judgment
Yes, sir.
Burro.
against Burro.
September 10, Greenscape purchases.
Well, no, in between Burro and the Greenscape purchases, the change from Burro to Burro Building and Property Maintenance.
That was before. That was in April.
Okay, after the verdict, but before the judgment.
Right.
So the verdict was,
The verdict was in December of '09.
Yes, sir.
The transfer from Burro to Burro Building, et cetera, was in April of '10.
Yes, sir.
okay,
The judgment gets entered against Burro Inc., and this is where the judge mentions in the transcript, like, it's kind of unexplained why it took 8 months to get this judgment entered, because by now, the new entity has come into existence, but the judgment is against the old entity, correct?
Yes, sir.
and that was a transfer of assets. Burro Property and Maintenance is a new corporation and that, to which the Burro Inc. transferred its assets.
Transferred everything, yes.
Okay, thanks.
And that's the basis of the proceeding supplemental motion, is that transaction in April of 2010 was exposes Burro Building and Property Maintenance to liability because of the simple transfer of assets pursuant to the fraudulent transfer statute. Same officer, same business, same location, same tax ID number. And in a lot of these cases, we don't even have records from the malfeasant defendant, if you will, actually saying what's going on. But in this case, we do. It was put forth in a deposition transcript that Manatee County had received from Catherine Davis, and she explains in that letter exactly what they're doing. We're just transferring all the business from Burro Incorporated to this new entity that we're in charge of, essentially. The tax ID number is going to stay the same, and everything is going to stay the
All
same.
right, well, let's come back. So Greenscape buys the second corporation
Yes, sir.
and continues to operate it.
Greenscape buys the second Burro building, okay, continues to operate it, recognizes that there was this lawsuit occurring.
That corporation continues to exist.
As far as I know, up until June 10 of 2013, when they filed a response in this case.
Okay, and so the proceeding supplementary filed in 2012 was directed to the Burro Property and Maintenance Corporation
Yes, sir.
that still exists.
Yes, sir.
Okay,
And the proceeding supplemental directed to them was providing very detailed allegations in the motion for proceeding supplemental to say, hey, you got all this improper business from Burro Incorporated. You knew about, you got to respond to this. And in response, they said, we have no response. We don't know anything about it. And the reason for that is the individuals that were financing Greenscape's purchase of Burro Building and Maintenance weren't on the scene in April of 2010. It was still the individual defendants in the case, the Davies, that were in charge of Burro Incorporated and Burro Building and Property Maintenance. at the evidentiary hearing on this case on the motion for proceeding supplemental and seeking an entry of final judgment against the new borough entity, at the outset of the hearing, myself asserted to the trial judge, wait a second, there can't be defenses to the relief being sought here because it's not been pled. One, they didn't file a response. Two, they filed a letter. It's not through an attorney. And three, their claim that they had no knowledge of the April 10 transaction isn't a defense of anything. That further, in opening, that was asserted. The judge didn't rule on that. I presented to the court the Archie Freed Florida Supreme Court case that evidentiary hearings are tried based on the framework of the pleadings. In closing, I interrupted closing argument when defenses were asserted on behalf of the impled defendant, the new borough entity, saying, wait a second, this is outside of the scope of the pleadings. The pleadings aren't sufficient. The pleadings actually say we don't have any knowledge of this transaction in April of 10. They shouldn't be allowed to be asserting defenses at this juncture. Now, the trial court ruled against me in her ruling on that issue. She specifically asserted or ruled that while it's suspicious, all these things, the intermingling of corporate affairs, the same business location, same officers through the corporate records that were put into evidence in the case, and the letter from individual defendant Davies on behalf of Burro Building and Property Maintenance. And while all that's suspicious, we still haven't carried our burden of proof that there was an improper transfer between the old borough entity and the new borough entity.
When the judge ruled, and we're getting close to the end of your time before rebuttal, but I'll give you both a few seconds. When the judge ruled in paragraph 2 of her order, Burro Building and Property Maintenance took the property in good faith and for reasonably equivalent value. What was the value?
Despite objections as noted on the record, there was testimony from the individuals in charge of the new borough entity that they had paid $200,000 for the new borough entity. And so that...
Okay, wait a minute. The green space had paid $200,000 to purchase the corporation?
Yeah.
But it seems to me the fraudulent transaction here, as alleged, is a transfer of assets from Burro to Burro Property and Maintenance.
Yes, that's correct.
Was there any testimony about any value given for that?
There was no testimony, no knowledge of that whatsoever.
All right, you're down to your 2 minutes.
I'll reserve then.
Okay.
Thank you, sir.
Good morning. May it please the court. My name is John Chapman. I represent the appellee, Burro Building Property and Maintenance, Inc. Just a few things. I think we've already hit on a few points that I think were kind of confusing but are important to note, that the judgment is against an entity called Burro Inc., correct, whereas the new entity is a separate legal entity that was formed at a different time.
Now, when Burro Inc. transferred its assets to Burro Property and Management, whatever it's maintenance, the verdict had been entered.
Yes.
So they know this judgment is coming. And what was the evidence regarding that? This was transfer of assets? Was value given?
The only, and my position with a lot of this obviously is and we look at it procedurally as far as what the burden of proof was and what the appellants here actually proved in our hearing before the trial court to support their allegations that they made in their motion for proceeding supplementary. Because that they had their proceeding supplementary when they made these detailed allegations, but what was actually set for hearing was their motion for final judgment against Burro Building Property Maintenance, Inc. And in that, they pretty much just alleged that Burro Building Property Maintenance is Burro Inc., therefore they're responsible for the
Yeah, but that's
judgment.
not my question.
Right, I understand, Judge. So we didn't know what there was when what we were going to be hearing when we get there. But yes, but as far as that, what the evidence at trial was the only evidence at trial was this transfer of the business that was alleged from Burro Inc. to Burro Building was the letter from Catherine Davies to the fellow at Manatee County saying, we're operating under this new business now. Basically, please transfer our contract.
Basically saying, hey, it's one and the same. And the contract, and one of the contracts that existed at the time the green space made its purchase was this contract that's referred to in the letter.
Exactly.
So that contract was initially with Burro Inc.
Exactly. Now, I think what's crucial is there was, I think the judge recognized this, was there was no evidence put on by the appellants here as to whether there was any consideration paid for the transfer of that asset to the extent that that contract was an asset. There's no allegation or there's no proof whether there was or was not. There was no proof, I think more importantly, what the value of that contract was. Again, that was their burden of proof to show that there was this transfer that was with the actual intent to defraud.
Well, what I'm again coming to paragraph 2. The judge actually makes an affirmative finding that there was reasonably equivalent value.
Well, I think what she was referring to there, Your Honor.
It's the second transaction,
yes,
the green space. And
that's
why is that relevant at all if that was a purchase of the corporation?
Well,
it wasn't a purchase of assets. That was a purchase. I mean, if they had purchased an asset that had been fraudulently transferred and given good value and had no knowledge of the fraudulent, I can see they're a purchaser in good faith for value, correct? Mm-hmm. But if they purchase the corporation, all they've done is assume ownership of an entity that may have liability for a fraudulent transfer.
Well, I think it's important they did not purchase Burro Inc. They purchased Burro Property and Maintenance Inc. And you can have subsequent.
They purchased a corporation.
Yes.
And if there was a fraud, if that corporation had an existing liability for a fraudulent transfer, why does the fact that the purchaser of the corporation doesn't know about it, why is that of any concern?
Well,
who cares who
like,
that
I guess the question is when the liability is fixed, because you can have subsequent transferees in a fraudulent transfer.
Of the asset.
Yeah.
But that's not what Greenspace bought. It bought the corporation.
Well,
it bought the recipient of the asset in the alleged fraudulent transfer.
Well, it was kind of frankly a sloppy closing. You look at the actual contract, it says it's an asset purchase agreement.
The problem, I think, is that the hearing doesn't really focus on the first transaction. And I think Judge Northcutt's right. I think that's probably the critical one. But the focus of the hearing was on Greenspace and whether or not they should be on the hook. And they weren't even a party to this.
Well, Greenspace is not on the hook at all.
Right.
Because that's a separate corporation that purchased a corporation. The question is whether the corporation they purchased is on the hook.
But we don't really know anything about the first transfer.
Well, there wasn't much evidence, and Judge specifically talks about that in her, and it's in the before we get to the I guess good faith purchaser aspect, which again is actually you could argue it's for the second transaction, not the first transaction. There was no.
If that was the purchase of a corporation, I submit that's wholly irrelevant.
Okay, I understand it, Your Honor. So as to the first transaction, the transfer of the Manatee contract from one corporation to the other, we assert it was their burden of proof initially to prove. We weren't arguing that that there was a good faith purchase. We weren't arguing a defense as to that transfer, Your Honor. I think that was their initial burden to prove that there was this transfer that was done without value, et cetera. And the judge specifically made the findings. She's going through the 726-105 factors and saying, well, it seems kind of fishy, this first transfer, but we don't have any evidence of whether there was value or not value, or again, what the value of this contract was. By the time my clients got this contract, they certainly assert that it certainly wasn't worth the $200,000 they paid, because this contract, which they anticipated would maybe be renewed, which was set to expire 6 months or so after they closed, would be renewed. They were led to believe that by the Davies, that it would be renewed, and it wasn't renewed.
Right, but that again, what Greenspace as a basically sole or majority shareholder of the Burro Property and Maintenance Corporation thought might be the case is just that would, if they were misled, then that would be between them and the shareholders who sold the corporation to them. But again, it doesn't affect.
Right. So going to the first, I guess again to the obviously the transaction Your Honor is focusing on, there wasn't much discussion of that at trial. There wasn't much evidence.
The judge's finding is in the order is not really specific. plaintiff proved several of the factors set forth to show actual fraudulent intent, but taking the factors as a whole, the court did not find that they proved. So it doesn't really outline the specific.
No, but she did go through those.
She did
in the
cite
transcript.
to the.
She did go through each of these, and I think the crucial thing is, one, it was their burden to prove, and two, the court, sitting as a trier of fact and listening to the evidence, made the finding, the specific finding that can't be overturned if it was based on substantial evidence, that unless it was not based on substantial evidence, that they did not meet their burden, and that there was not proof of the factors which would establish that this transaction or the transfer of the contract was done with the intent to hinder and defraud the plaintiffs here. So, I understand certainly, Judge Northcote, your position about what this one, that when you look at these two, I guess, separate transactions, obviously I understand you get into, well, it obviates a lot of the need to get into whether there was a good faith purchaser, whether that was that.
If they had purchased the assets, then you would have a BFP situation.
Right, right.
But by buying the corporation, all they did was buy an entity that may have a liability.
Right. So one could argue we never have to get into the argument of whether the burden shifted. We never have to get into the argument of whether whether my clients were good faith purchasers or whether they themselves, just like the Wingates, were victims of the Davies. We don't have to get to that. But what we did get to is it was the plaintiff's burden to carry their burden here to prove a fraudulent transfer. They didn't offer sufficient evidence of that. The court made a finding, a fact, that they didn't carry their burden. And that's why I believe that the trial court's order should be upheld.
Okay. Thank you, Mr. Chairman.
In brief rebuttal, there's an argument being said, well, we don't know what the consideration was paid on that April 2010 transfer between the first Burro entity and the second Burro entity. Let's look at that in realistic terms. The Davies are in charge of the first Burro entity. They're in charge of the second Burro entity. So is the burden for my client to come up here and say, oh, or at trial to say, well, we tracked down the Davies through their bank accounts and they transferred $10,000 between their bank accounts, and that must have been the consideration paid between the corporation owned by the Davies, the first Burro entity, and the corporation owned by the Davies, the second Burro entity. I don't think that that's realistic. That's not in keeping with what actually happened in this transaction. I don't think anybody in the room thinks that the Davies actually paid themselves from the new Burro entity to the old Burro entity or anything like that as a part of their transfer. What's realistic is, based on the evidence presented, and it's a lot of evidence, by a preponderance of the evidence, corporate records from both Burro entities, okay, showing the same business location, same tax ID, same officers. There was testimony on my side of the aisle connecting the dots of the officers, showing that the Davies' daughter and son-in-law was also officers of the new Burro entity and the like. And in this case, there's an actual letter from the defendant, Davies herself, saying this is essentially what we're doing. We're transferring the business from Burro Incorporated to the new Burro entity, and it actually states that on their letter. It uses the new letterhead. That's part of the evidentiary record that was before the trial court. That's what's occurring in April of 2010. I don't want the analysis of this proceeding to get confused also with what happened in September of 10 with the purchase of this entity. The court is correct. When there's a purchase of the entity, that comes with the liabilities if there's a fraudulent transfer that occurred previous to that. Thank you, Your Honors.
Thank you both very much.